Ladies and gentlemen, it is a singular honor for me to give a keynote address to such a distinguished gathering of both local and international members of the Chartered Institute of Arbitrators. The topic for your conference is International Arbitration for the 21st Century, a new era of dispute resolution in Africa. I find this topical issue apt and to which Africa ought to respond to as a continent. Given the current international economic order resulting from the effects of globalization, the establishment of effective and reliable modes of resolving commercial disputes are desirable and invaluable. Whereas commercial and international trade disputes are unavoidable, efficient mechanisms for the resolution and management of such disputes are essential. The resolution and management of such disputes lie in alternative dispute resolutions, ADRs, mechanisms that are ways and methods of resolving disputes outside the judicial process and include negotiations, conciliation, mediation, and arbitration. Madam Chairperson, this conference focuses on arbitration. Practitioners aver that arbitration is an efficient and timely method of resolving and settling commercial disputes. I need not say more, but to affirm that arbitration is a jurisdiction in which parties to a commercial contract establish as their own entity to resolve disputes. You could say that the parties establish a private tribunal for the resolution of disputes arising from contract performance. It is hence assumed that the resulting awards from the arbitral process should provide certainty and finality. I understand and believe so that disputes arising out of commercial transactions primarily require a commercial approach to their resolution. It is a global reality that business is concerned more with getting an occupational solution to a commercial dispute rather than be dragged into lengthy and protracted procedures in court. Needless to say, Africa's experience is that international business community is usually reluctant to resolve commercial disputes in domestic courts. Hence, commercial disputes are today increasingly resolved by arbitration in the various established international arbitration centers. This is enough evidence that there is need for Africa to adopt international arbitration as the 21st century mechanism for resolution of commercial disputes. Unfortunately, as presently set up and constituted, the Nairobi Center falls far short of a truly international commercial arbitration institution because of the following reasons. It is a statutory institution established and set up in the same manner as other public statutory institutions, and assigned functions almost similar to those assigned to a state entity. In the eyes of the international arbitration community, the Nairobi Center is more of a public than a private entity. Madam Chairperson, one can rarely find an international commercial arbitration center which can perform the plethora of unwieldy functions as assigned to the Nairobi Center under Section 5 of the Act. Consequently, since establishment, the Nairobi Center unless I'm very, very wrong, has not serviced any case of international commercial arbitration. The Nairobi Center should therefore be reconfigured to offer international arbitration services. Let me repeat this. As presently established, structured, and constituted, the Nairobi Center cannot attract international commercial arbitration business to this country. It is established and structured as any other state corporation with strong state control and minimal private, commercial, and business orientation and participation. In short, it is not an appealing businessman's center for international commercial arbitration. I say so because I have been moving a lot, and this message is coming again and again and again. I was out there at a Commonwealth Business Conference, the message comes through. There are issues that could have been dealt with here. People are still heading to Paris, to London, to Italy to solve these issues. Even within contractual obligations that are being entered into today, the experts are still writing into those contracts different destinations for dispute resolution. That means we have a problem. I therefore propose that given the central position Nairobi has as a business and financial hub in the sub-region, it should have an international commercial arbitration center that espouses and mirrors the experiences of other established centers. I need to emphasize that the primary function of such a center should be to provide efficient international dispute resolution services that support and serve international business seeking to resolve commercial disputes. I am glad to inform this esteemed International Arbitration Conference that as a government, we are taking steps to ensure that Kenya has a world-class institution capable of providing international commercial arbitration services in Nairobi. My office, in close consultation with other relevant agencies, including the Office of the Attorney General, are at an advanced stage of developing a bill that will ensure that the establishment of a viable private international arbitration center in Nairobi is put in place.